Well, it's a very good afternoon, ladies and gentlemen. Receive very warm greetings from the East Africa Law Society, situated in Arusha, Tanzania. My name is Gabriel Achaye, and this afternoon we are really humbled and honored to host you for this very important discussion on understanding the critical role of courts in arbitral disputes. And today we'll be sharing experiences from across the region. We have experienced panelists who have a wealth of knowledge in this field of arbitration and, of course, have interacted with the subject matter severally. Our session this afternoon is moderated by a very seasoned advocate and a good friend of mine, Mr. Ambrose Weiger, who is a senior associate at CM Advocates LLP and a seasoned legal expert with about 7 years of robust experience in alternative dispute resolution and commercial litigation. He has a track record of high impact cases. He's participated in groundbreaking arbitral matters across sub-Saharan Africa, and he has strategic insights and practical expertise that have been pivotal in shaping the litigation landscape of East Africa. Mr. Ambrose Weiger is an alumnus of Moi University, and he holds a postgraduate diploma from the Kenya School of Law, and he has distinguished himself with specialized certifications in FIDIC conditions and of contracts, intellectual property and data protection, and he's greatly involved with professional bodies like the Law Society of Kenya and the East Africa Law Society, where he's very committed in offering services and insights at the different bar associations. Mr. Waigwa, we are profoundly honored and exceedingly humbled to host you this afternoon and have you moderate the session. But before I hand it over to you, I would like to inform members present on this call that this next week, for the first time in East and Sub-Saharan Africa, the East Africa Law Society will be hosting the first ever international space law masterclass. If you're enthusiastic to learn about space law practice, please register for this masterclass. Held in partnership with the Institute of Air and Space Law at the McGill University in Canada. So we look forward to hosting you in Nairobi next week. Grab your slots while it still lasts. And for now, I'll hand over to my good friend, Mr. Weiger, to take us through the session till 4 p.m. Mr. Weiger, I'll hand it over to you now.
Thank you very much, Gabriel. Good evening, ladies and gentlemen. We are honored to host you in this webinar by the East African Law Society. In recent times, arbitration has become the most preferred means of dispute resolution, as parties opt for arbitration instead of filing disputes in court. However, there are needs when courts need to intervene in the course of the arbitral proceedings. According to a writer called Redfern and Hunter, it is sometimes said that the relationship between national courts and arbitral tribunal is one of partnership. If so, it is not a partnership of equals. Arbitration may depend upon the agreement of the parties, but it is also a system built on law and which relies upon the law to make it effective nationally and internationally. National courts exist without arbitration, but arbitration could not exist without the courts. A number of scholars have also defined this relationship between courts and the arbitral process as one that swings between forced cohabitation and true partnership, and also emphasize that the arbitral process relies upon underlying support by courts, which alone have the powers to recuse the system when one party seeks to sabotage it. Professor Julian, Queen Counsel, opined, national court involvement in international arbitration is a matter of life as prevalent as the weather. The relationship between national courts and arbitral processes has many facets and has evolved from being treated by national courts as an inferior dispute resolution mechanism in which it is one in which each has a different role to play at different times. In essence, we would say that the real issue here is to define the point where the reliance on arbitration on national courts begins and where it ends. Our speakers for today are Olivia Matovu, member of Chartered Institute of Arbitrators, who will discuss largely the relationship between national courts, arbitral tribunals, and the jurisdictional tensions therein present. We also have present Madeleine Kimei, the president of the Tanzanian Institute of Arbitrators, who will discuss the different ways the two systems of adjudication can symbiotically coexist and cooperate in the same space. We have Genevieve Akelo Atiang, Director, Restore Dialogue Uganda, who will discuss the role of courts in settling the boundaries of arbitration, supporting arbitration, and setting aside an enforcement of the arbitral awards. We have Victor Mugabe, the Secretary General of Kigali International Arbitration Center, who will discuss the different spheres in the arbitral process where courts may influence and how the two intersect. I am your moderator, once again, Ambrose Waigwa, an associate CM Advocates LLP Nairobi, who will coordinate the discussion during this webinar session. Olivia Matovu is a seasoned advocate and an international arbitrator with over 18 years of experience. Her expertise spans commercial disputes, international arbitration, employment law mediation, litigation, security enforcement, insolvency litigation, infrastructure and construction litigation, and tax. She is currently a partner at Legomark Advocates and serves as a dispute resolution practitioner, providing advisory and resolution services to various corporate entities, including commercial banks, statutory corporations, NGOs, and private entities. She focuses on commercial litigation, conflict, and dispute settlement. She also focuses on policy and regulatory reform, arbitration, and mediation. She is a panel member at the International Center of Arbitration and Mediation in Kampala. She is a professional advisor and lecturer at the Law Development Center, Kampala. She is an honorary treasurer at the Chartered Institute of Arbitrators, the head of training and accreditation at ICAMEC, and a member of the organizing committee of the American Bar Association Masterclass in International Arbitration 2023. Last but not least, she is a mother and a wife. She holds an LLM International Dispute Resolution, Commercial and Investment Arbitration from Queen Mary University of London, a certificate in International Commercial Arbitration, Chartered Institute of Arbitrators Kenya Branch 2017, a certificate in Introduction to Arbitration and ADR course, Chartered Institute of Arbitrators Kenyan Branch, Special Diploma in Trial Advocacy, National Institute of Trial Advocacy USA, certificate in Basic Mediation Skills, High Court of Uganda, Commercial Division, a postgraduate diploma in legal practice from the Law Development Center, Kampala, and Bachelor of Laws from Makerere University. She is a panelist in various conferences, including the 7th Chartered Institute of Arbitrators Kenya International Conference 2023, the first National Alternative Dispute Resolution Summit Uganda 2023, the 9th East Africa International Arbitration Conference, Kigali, Rwanda 2022, the East Africa Law Society Conference on ADR 2022, the 2nd Annual Africa Arbitrators Association International Arbitration Conference 2021, and Uganda Registration Service Bureau Insolvency Conference 2019. She is a member of the Chartered Institute of Arbitrators UK, Chartered Institute of Arbitrators Kenyan Branch, London Court of International Arbitration, Africa Users Committee, Young International Arbitrators Group, International Center of Arbitration and Mediation, Kampala, Editorial Board, Uganda Law Reports, Uganda Law Society, East Africa Law Society, and Arbitration Cluster, Uganda Law Society, where she is the chairperson emeritus. Olivia is highly regarded in her field, contributing significantly to the growth and development of arbitration and dispute resolution in Uganda and internationally. We also have with us Genevieve Akelo, a distinguished Ugandan lawyer and advocate with over 7 years of experience in litigation, corporate and commercial law. She has successfully represented clients in high stakes and high value cases across both national and international arbitral tribunals, and has successfully negotiated settlements through mediation. Beyond her legal practice, Genevieve is deeply committed to professional development. She serves as a faculty member in the law firm management program, where she facilitates discussions and shares her insights on contemporary legal practice. She also facilitates leadership development programs designed to enhance workplace culture in high-performance organizations. She is currently a director at Restore Dialogue Uganda, an organization that provides alternative dispute resolution services and international mediation training. We are also joined by Mr. Victor Mugabe, the Secretary General of Kigali International Arbitration Center, Rwanda, a position he has held since January 2021. Kigali International Arbitration Center is the premier and sole arbitration institution in Rwanda, established as part of investment climate reforms. As SG, Mr. Mugabe serves as the head of and registrar of the center, overseeing the administration of arbitration and mediation cases filed there. Before joining Kigali International Arbitration Center, Mugabe served as the executive director of the Rwanda Bar Association from April 2012 to December 2020. Additionally, he was the coordinator of Justice, Reconciliation and Law and Order Sector Secretariat in Rwandan Ministry of Justice from 2010 to 2012. His experience spans legal and institutional development, international arbitration, and other alternative dispute resolution mechanisms. Rwanda, where KIAC is based, is known for its arbitration-friendly legal environment, making it an attractive hub for resolving commercial disputes. In fact, Kigali International Arbitration Center is hosting the joint ICCA KIAC conference in 2025, which will bring together arbitration practitioners from around the world. Later in the session, we will be joined by Madeleine Kimei, a member of the Chartered Institute of Arbitrators and a fellow in Tanzania Institute of Arbitrators. She is an independent arbitrator, commercial mediator, advocate, and principal of iResolve Tanzania. She has over 15 years experience as a corporate and commercial counsel in various sectors, including banking, telecommunication, mining, construction, and trade. Kimei has acted as counsel, party-appointed arbitrator, adjudicator, and mediator in both domestic and international arbitrations. Her work also involves ADR advisory and support for tribunals as an arbitral secretary in complex arbitration. Madeleine is a trainer to public and private institutions and the faculty of International Law Institute, Washington, for online dispute resolution, and the Bangladesh International Mediation Society. She speaks and writes on dispute resolution topics. Kimei sits on various panels, including the ICSID panel of conciliators, European Commission list of arbitrators suitable for appointment as chairperson in arbitrators under trade agreements to which AU is a party, Tanzania Institute of Arbitrators, SADC AFSA, Shanghai International Arbitration Center, Bali International Arbitration Mediation Center, and recently AAA ICDR. She holds several directorships. She is currently sitting her second term as the president of Tanzania Institute of Arbitrators and a member of the LASIAC Court of Arbitration. Most significantly, she has received various recognitions in the field, namely the 2023 ADR Recognition Award from the Judiciary of Tanzania, Mediation Center, and being listed among 100 Tanzania Changemakers 2023. As my learned friend Gabriel said, this session is intended to last 2 hours and end at 4 p.m. The session is being streamed live on Zoom, YouTube, and Facebook. Feel free to write down your comments as the session progresses, and also to make any questions or comments that the panelists can deal with at the end of the session. To start us off, we invite Ms. Olivia to take us through the supportive roles of court in supporting arbitration agreements. Ms. Olivia.
Thank you, Ambrose. Good afternoon, colleagues. I would like to first of all thank the East Africa Law Society for inviting me to share insights on this topic. I know that many of us on this call have had experiences in the relationship between the courts and arbitral tribunals, and if there are any tensions between the two regarding jurisdiction. So I'll share my insights, and I hope many of you will also be sharing those insights as we go along. Ambrose, allow me to share my screen.
You may now share your screen.
All right, thank you very much. So essentially, one of the items that I'll be discussing, that relationship of the courts, is the enforcement of arbitration agreements. And I think, as Ambrose has already said, gone are the days when there was an acrimonious relationship between courts and arbitral tribunals. Previously, there was that fight for jurisdiction. And in Uganda, we had that time when courts would say the High Court of Uganda has original jurisdiction over all matters, and therefore a clause in the Arbitration and Conciliation Act could not oust the jurisdiction of courts. So you'd find that where a matter is filed before the courts and maybe a party raises the fact that there's an arbitration agreement, the courts insisted that they were the superior and that the Constitution of the Republic of Uganda gave them the power and the mandate to adjudicate disputes, and therefore a private contract between parties could not then now oust their jurisdiction merely because parties have agreed to refer their dispute to the courts. But gone are those days now, and that collaborative relationship is anchored under the international instruments and international arbitration instruments, and also the national laws. So I'll speak to the Ugandan laws, but also give some instances of where we have seen other jurisdictions where the courts have embraced arbitration and recognized the arbitral tribunal's mandate or jurisdiction. So one of the ways that the courts support arbitration is through enforcement of arbitration agreements. And essentially, arbitration agreements are agreements between parties to refer disputes that arise between them regarding transactions they engaged in, any contracts, or any legal relationship that they have, to arbitration. So that is the arbitration agreement. And most times we find that either in a commercial contract or a contract, and you find that there will be a clause in that contract that specifically speaks about reference to arbitration, or you might find a specific arbitration agreement where parties have actually signed an agreement to refer any disputes that may arise out of their commercial relationship or any legal relationship to arbitration. Or you may find one where parties, after the dispute has arisen, they may never have thought about how to resolve it in their contracts, but after the dispute has arisen, they choose then to agree to refer the dispute to arbitration, and that usually is called a submission agreement. So the courts have been supportive in terms of ensuring that arbitration thrives. And in Uganda, under our jurisdiction, the courts are mandated under the Arbitration and Conciliation Act, Section 5, to refer matters where to stay any case filed in court if there's an arbitration agreement in the contract, or if there's an arbitration clause in a contract between the parties. The courts are required to stay any court proceedings and refer the matter to arbitration. And also Section 9 of Arbitration and Conciliation Act also restricts the court's intervention in matters of arbitration to only those powers or those only to the mandate that is provided for under the Act. So the Arbitration and Conciliation Act has specific instances where the courts, the national courts of Uganda, can actually intervene. And it's only in those specific cases that then somebody can go to court. If it's outside that, the courts are restricted from interference. So, and therefore, in that way, we have seen that there are some cases in Uganda, and there are a couple of them, but I'll just give one where the pro-arbitration approach of Ugandan courts was actually clearly demonstrated. In this case, Security Group Uganda Limited versus Finasiru Construction SPV. It's a high court case. In this particular matter, the contract had a provision for reference of disputes to arbitration but it also provided for reference of disputes to litigation. And I think that's not strange for many of you who have gone through some of the contracts. You'll find that under the dispute resolution clause, either parties are provided that the matter shall be referred to, if any dispute arises, shall be referred to arbitration. And then they also provide, and should arbitration fail, the matter shall be referred to the courts, let's say of Uganda, you know, or the matter shall be referred to litigation before the courts of Uganda. So in this case, the matter had two dispute resolution mechanisms, which you could say were contradictory to one another, because as we know, you can't have both arbitration and litigation at the same time. Both are final dispute resolution mechanisms, and you must choose one. So in this particular case, the court, notwithstanding the fact that the clause had two mechanisms, the court respected the arbitration clause. And the court decided to enforce the arbitration clause by referring the parties back to arbitration, notwithstanding that there was a clause that provided for litigation. Of course, one of the parties was arguing that, you know, there had been a clause on litigation, but and that was what compelled the plaintiff to file a suit in court. But when the matter came up before the judge, the defendant raised the objection to the case proceeding because there was an arbitration clause. And then the court took a more proactive approach in terms of interpreting the arbitration clause or the dispute resolution clause, and found that the intention of the parties, when the court reviewed the facts of the case and the contract, underlying contract, was that the intention of the parties was to refer the matter to arbitration and not to litigation, and the court therefore enforced the arbitration agreement. Like I said, there are a couple of cases where that has happened in the Ugandan jurisprudence, where parties have filed their cases in court, and there's existence of an arbitration clause within the commercial agreement. And once that issue is raised before the judge or a judicial officer, then the courts have actually referred the matter back to arbitration. So in that way, we have seen that the court's role and the relationship between the courts and arbitral tribunals is supportive. It supports arbitration. Obviously, at that point in time, there's no arbitral tribunal. Sometimes there's no arbitral tribunal in existence. Sometimes an arbitration is ongoing and the party seeks to become stubborn and still goes to court because they don't respect the arbitral process. But once it's brought before the courts refer the matter to arbitration. The other case I want to refer us to is a South African case, and I just said I wanted to use other jurisdictions as well, to demonstrate the supportive role of courts in enforcing arbitration agreements, and that is the Lukoil Marine Lubricants, DMCC, versus Natural Energy Resources and Commodities Limited. And in this case, again, there was an arbitration clause in the contract, and it required that the arbitration would be undertaken in London, and that it would the English arbitration marine laws would govern the arbitration process. When there was a breach in the transaction, the party filed a case in the High Court of South Africa to stay the application to seek return of the goods and repayment of sums in the contract. But because the court was brought, the arbitration agreement was brought to the attention of the court, the South African court then said they could stay that application, which sought return of the goods and repayment of the sums involved, pending the finalization of the arbitration proceedings that were ongoing in London. So you could see that in that case, the remedy that was being sought by the party would have had an impact on the outcome of the arbitration in London, and the court was cognizant of the fact that that would have an impact and that the arbitration was ongoing. So therefore, no application would be had until the conclusion of those proceedings, and probably to see whether the proceedings did not handle that issue. So for now, Ambrose, the first part I've spoken to is the relationship which leads to enforcement of arbitration agreements. Thank you. Hello?
Thank you very much for that session. Now we will invite Genevieve to speak on enforcement of arbitration agreements.
Thank you, Ambrose. I hope I can listen.
Yes, we can hear you clearly.
All right. Okay, thank you so much. So I'll just speak to enforcement as more of a discussion. Didn't exactly prepare a PowerPoint. Enforcement of arbitral awards depends on a number of principles that are dependent on the law, either of the country where the enforcement has been applied for, or the law of the seat. It's greatly determined by the law of the seat, because that is where enforcement is to be done. So for instance, the parties need to agree that the seat of arbitration will be such and such country, and that informs the principles and laws that will govern enforcement thereafter. Okay, so the first thing to note in enforcement is that it's only available for final awards. Okay, you cannot apply to enforce a ruling or a decision of the tribunal on preliminary matters, things to do with what jurisdiction, things to do with interim orders and so on. It has to be a final award. So how you determine, how the courts will consider that something, a decision of the tribunal is a final award, they will use the criteria that includes things like, does the decision involve procedural questions like jurisdiction? Is it about a standing? Is it about limitation? Is it about which law is applicable to the arbitration? So where it's about those matters, it's usually determined that it's a preliminary issue and it's not a final award. So a final award has to be a decision that determines all issues in dispute, or gives a final decision on a partial, on one or more of the disputes. That's when it will be called a partial award. So it's important to note that a partial award is different from an award that is still preliminary or procedural. A partial award deals with one or two, some of the disputes in full. Okay, but preliminary issues do not deal with the subject matter. It does not resolve the issue finally. So a partial award can be enforced, whereas procedural rulings cannot be enforced. That is the first criteria, really. And then the other consideration for enforcement is that is the application to enforce barred by limitation. That has to be considered. Under the Ugandan Arbitration Rules under the Arbitration and Conciliation Act, Rule 11 provides for 90 days within which an application to enforce an award as a decree of the court should be made. If no objections are made to that application, so it has to be upon expiry of the 90 days of filing a notice to enforce. So the first thing that a person must do after receiving decision of the tribunal is to, well, have it certified. It should be in writing. There are also those considerations. It should be a decision that is signed in writing, certified, you know. And then the person must file it in court, file a notice to the other party, serve the notice to the other party of intention to enforce that award. Okay. Then under Rule 11 of the arbitration rules, the other party is given 90 days within which to object to the enforcement of that award or accept it. So where they don't object, for instance, it is deemed that they've accepted and therefore it can be enforced. So for instance, the courts are very critical about timelines, as was noted in the case of Rocco Construction Limited versus Mohammed. This was a civil appeal, number 51/2011, where an application to set aside an arbitral award was made 6 months after the date of the award delivered by the arbitrator, and it was dismissed for being incompetent. So it's important that somebody who intends to benefit from an award or a successful party is mindful of the timelines within which they should enforce that award. One of the first steps that the court considers also is recognition, especially in terms of foreign arbitral awards. Under the New York Convention, as we know, foreign arbitral award can't be enforced in any country that is signatory to the New York Convention. So, for example, if a foreign arbitral award is brought for enforcement, the courts will consider, first of all, whether it's authentic from the country where the award was issued. That is, supposing that the seat, for example, let's say that the seat is Uganda, okay? And a person applies to enforce an award in Uganda. So the court will first of all consider whether it's authentic, and I've just explained the consideration for authenticity, should be certified, should be signed by the tribunal, and so on. And then the courts will check whether that issue has already been decided in the courts of law. It's not res judicata in that country. For example, that means that there should not be another court proceeding on the same issue, same parties, the same dispute being brought before it for enforcement of an arbitral award. So once that is done, once those preliminary checks are done, then the award is recognized. However, recognition doesn't mean that it's going to be recognition doesn't mean it's going to be enforced, because it then has to pass additional checks or consideration or standards. Okay. So, for example, in the Great Lakes case, the case of Great Lakes versus Sabo and about 5 others, the applicants applied to set aside 2 partial awards, and the court there, although it was an application to set aside, the court really considered grounds for enforcement of an award, because the other side then objected, and they applied that the award should actually be recognized. It was an award from the London Court of International Arbitration. So in that case, the court noted that, second. Okay. So the court went into discussing the difference in a partial award and a final award, as I've just discussed. And then the court also noted that principles that will govern enforcement, such as being mindful that the court is not stepping into the arena of reviewing the arbitral award in one way or the other, or going into the merits of the case. The issue of enforcement had to meet all the strict considerations, including limitation, including authenticity of the award, and including the finality of the decision, as I've just explained. Court also went into discussing recognition, as I've also explained, and noted that recognition produces effects such as preventing re-litigation, and then also offering recourse to the public to execute. So once it passes all those tests, then the award can be executed and enforced as a judgment court. Thank you, Ambrose.
Thank you very much, Olivia. I mean, Genevieve. Maybe you can also take us through how courts go about handling challenges to awards.
Oh, okay. Thank you, Ambrose. You had said I go straight to enforcement, and I think they go hand in hand with setting aside an award, because most times the other side will be fighting to have it either nullified or set aside, and then the other side wants it to be recognized. All right. I'm happy to take us through procedure for setting aside an award and considerations thereunder. So for setting aside, where an application is made to set aside an arbitral award, say that during the 90 days, for example, somebody objects to the award, to the enforcement of the award, they have to show grounds for their objection. And these grounds are very limited, because remember, the principle is to support arbitration, to uphold an arbitral decision, and for the courts not to interfere in the entire arbitration process, except to support it, as Olivia had earlier explained. So there are limited grounds for setting aside an arbitral award, and they're only centered around jurisdictional issues procedural issues, or public policy related grounds. Section 34. Sorry, I'm going to take you through provisions in the Arbitration and Conciliation Act, because this is I'm presenting from Uganda. However, I'm mindful that our audience is from a wide array of nationalities. So the ancestral rules, ancestral model law, for example, under Article 34, that's the more general provision that is recognized by all the East African countries. So Article 34 provides for grounds for setting aside, and these include where the award is not valid under the law to which that the parties have subjected it. So, for example, if they want to enforce an award in Tanzania, and the Tanzanian law does not recognize the validity of that award, okay, then somebody can apply to have it set aside. The other reason is that a party was not given proper notice of the appointment of the arbitrator or the arbitration proceedings and could not present its case. This goes down to fair hearing. If the party didn't know about the arbitration or those procedures for fair hearing were not observed, and therefore there was a total failure on their part to present and defend themselves, then they can apply to have the award set aside. Also, where the award deals with a dispute that was not anticipated or submitted or referred to arbitration, or where it exceeds the scope of disputes that were agreed upon by the parties, would be referred to arbitration, then the other party can apply to have the award set aside. Then lastly, where the court finds that the award is in conflict with public policy of that country, then they can set aside. Now, coming back to Uganda, which act, our Arbitration and Conciliation Act is actually similar across the region. The provisions may differ, but the principles are similar. So, for example, under the Arbitration and Conciliation Act of Uganda, Section 34(2), it has additional grounds, so many more grounds actually. For example, a party was under some incapacity and they could not participate in the arbitration, then they can apply to have it set aside. Where the party, okay, there's the issue of the notice, that's similar. If they were not given notice of the appointment of the arbitrator, or the arbitration agreement was not valid, that's also under the Ugandan law. And then where the award contains decisions that were not contemplated in the arbitration agreement, okay, that's also similar to the ancestral grounds. And additionally, where the composition of the arbitral tribunal or the arbitral procedure was not as agreed by the parties. Okay, so this comes down to issues where the tribunal that decided the matter was not agreed upon one way or the other. And then where the arbitral award was procured by corruption or fraud or other undue means, a party can apply to have it set aside. As you know, fraud generally invalidates a lot of transactions, including arbitral awards. Then where it's not capable of settlement under arbitration, under Ugandan law, that is where you hear instances of being contrary to public policy. If Ugandan law says that such a thing cannot be arbitrated, and that means you cannot have an award on the issue. For example, divorce, an arbitral award on divorce might be considered contrary to public policy in Uganda. You can think of other examples as well. So basically, the reasons for setting aside an award, as you will note, do not go into the merits of the decision unless it's completely legal, but go into the process that informed the decision, if you will note. So things like the hearing, things like the composition of the tribunal, as I've just listed, can then form grounds for setting aside. Ambrose, I think that's all on setting aside right now. And I'll discuss more later in the plenary.
Thank you very much. Olivia, you spoke about the role of courts in supporting arbitration agreements. Maybe you can tell us whether there are times when the courts have refused to support the arbitration agreements, and maybe up to what level of interference the courts have gone into in regards to that. Olivia, you can hear me?
Hello, apologies, Ambrose, I think I lost you somewhere.
We wanted to find out from you up to what levels the courts will interfere with arbitration agreements, having heard from you on the role of courts in supporting arbitration agreements. Does it end in the appointment of arbitrators only, or is there other instances when the court can interfere in that regard?
Well, and I don't want to use the word interfere, though I would like to use the word support. Well, Genevieve talked about appointment, I think, of arbitrators, if I had her, in terms of some of what courts can do. And that's so if probably the arbitration agreement gave the power to the court. So if the agreement parties actually gave power to court to appoint an arbitrators on arbitral tribunal, then the court will come in and appoint. But where the agreement has a specific appointing authority, let's say an institution, or let's say that parties agreed to appoint by agreement, then the court ordinarily would not have a role there. But where the parties have agreed to it and have failed to agree in our jurisdiction under the Arbitration and Conciliation Act, the Act provides for a party to apply to an appointing authority. Now we have two appointing authorities under the Act. We have the Center for Arbitration and Dispute Resolution, a Center for Alternative Dispute Resolution, that is CEDA, and then we have the International Center for Arbitration and Mediation in Kampala. So those are the two appointing authorities. In the event where parties had agreed to appoint an arbitrator or a tribunal, and then they disagree, they fail to appoint, then you make an application there for appointment. There have been scenarios where, sometime back, where the court had, in a way, passed a decision that put a freeze to the powers of CEDA, and yet parties needed to proceed into arbitration. So it was in those circumstances that parties would go to court and indicate the fact that there was that decision, which was curtailing CEDA's ability to appoint arbitrators, and yet parties at that point had no other alternative. ICAMEC was not yet in place. So at that point, parties now would invoke the jurisdiction of courts to exercise its power to promote justice, to ensure progress of arbitration, to assist in appointing arbitrators. So the other ways that the courts support beyond enforcement of the arbitration agreements is in terms of providing interim protective measures. And interim protective measures may be, to use the language that is, if there are any litigators here, is, let me call it preservatory orders, orders that enable the preservation of probably assets, preservation of evidence, preservation of property, or orders that issue injunctions to restrain certain actions pending the outcome of the arbitration proceedings. So the courts are mandated in Uganda and in other jurisdictions, I believe, to support the arbitration process by issuing these interim protective measures. Now, one of the stages at which the courts will come into support is before an arbitral tribunal is appointed. So many times a dispute has arisen, and parties have commenced with the preliminaries of arbitration, for example, issuance of a notice of arbitration, but the arbitral tribunal itself has not yet been constituted. So Under our Act, Section 6 of the Arbitration and Conciliation Act, parties can actually approach court and apply for an interim protective measure. They could apply for an injunction, they could apply for a freezing order, they could apply for an order preserving assets. So depending on whatever the remedy they seek. But that remedy is a temporary remedy pending the appointment of the arbitral tribunal, but also it could be pending the outcome of the arbitration process, entire process. So before the tribunal is appointed, the courts can support in that process. I know that the arbitral rules that provide for emergency arbitrators to be appointed to actually provide such remedies. There are institutional rules and actual jurisdictions where emergency arbitrators can be appointed to actually do that, exactly that, to issue protective measures, so to speak, pending the formal appointment of a tribunal. But in Uganda, the Arbitration and Conciliation Act also gives that mandate to the court to provide those remedies. But also during the arbitration proceedings themselves, the courts can be approached to provide the same remedies, interim protective measures to parties while the arbitration is ongoing. Now, the courts have recognized that jurisdiction and in the circumstances is a concurrent jurisdiction, in the sense that a party can opt to apply to the arbitral tribunal itself to grant it that remedy, or can go to the courts and apply for the remedy. So the courts have, in so many ways, talked about the concurrent jurisdiction of the courts in that section, and they've said that the two can actually serve the purpose. However, the court also noted that sometimes it's more strategic probably to apply to the courts, because one, the order might be sought against a third party to the arbitration. So, for example, there's an arbitration ongoing, and they need an order to freeze funds in a bank account, which is not a part of the arbitration proceedings. So, in those circumstances, much as the arbitration is going on between these two commercial parties, the third party, who's the bank, who's not a part of the arbitration, may not be bound by the interim protective measure being issued by the arbitral tribunal. So courts have said in those circumstances, then the parties can go to the court and they are helped. It could also be that in terms of enforcement, that when the parties consider if once they obtain that interim protective measure, from the tribunal, whether they can enforce it in terms of have the courts recognize and enforce it. And many times, especially there have been cases even in Uganda where the courts have said, because an interim protective measure is not a final award or a partial award that deals with the dispute and solves an issue within the merits of the dispute, the Act does not consider it an award that is recognizable and enforceable. So in those circumstances where you obtain an injunction, for example, to restrain movement of goods from one place to another from a tribunal, and then you'd like the party to comply, but the party has not complied, the court cannot now register or recognize and enforce that injunction because it's not a final award, neither has it dealt with some of the issues partially in the dispute. So because of that, for you to be able to have the order have post enforcement mechanism behind it, better to go to the court for the interim protective measure, because with that order of court, definitely it will be enforced. So the case I would like to refer to that has discussed those, and there are a couple of cases, but from our Ugandan jurisprudence, one of them is Captain Joseph Charles Roy versus D&D International Uganda Limited, the business application number 283 of 2018. In this application, the court discussed, first of all, that relationship between the courts and the tribunal, and the fact that the role of the court, one, is to support the tribunal in granting such kind of remedies to the parties, either before the commencement of that arbitration or during the arbitration. And the court mentioned those same factors I mentioned, the fact that sometimes parties may opt to go to court, whereas the tribunal could issue them the same remedy because of the force of compulsion that is behind the order when it's issued by the court, and therefore it can be enforced. But one of the things that I would like to state under that is that because of that concurrent jurisdiction that the courts have and the arbitral tribunals, there's a risk of jurisprudence tensions, or jurisdiction tensions. And this was clearly demonstrated in the Captain Joseph Charles Roy case, and that's why it's one I decided to use in this discussion, other than all the others that speak to these principles. In this particular case, before the arbitration had commenced, one of the parties had applied for an interim protective measure from court, and then court had dismissed the application. Now, when the arbitral tribunal was constituted, the party went back to the tribunal and applied for the same interim protective measure from the arbitral tribunal. The arbitral tribunal granted the protection. And then the other party now went to court to vacate that order, challenging, and one of the grounds was that court had already considered that application, had dismissed it. So this party went back to the tribunal now and got the remedy. So I would equate it to forum shopping of sorts. So in this particular case, the court highlighted that it's wrong for a party to now go back to the tribunal to seek the same remedy that had sought before the courts, and the courts had dismissed that. So you can see that there's an issue of a tension. Now, court has already made a decision regarding the same facts, same circumstances, same parties, and then a party decides to go to the tribunal to seek the same remedy, and they are given. But the ultimate was that the court also said that, however, where there are new facts and new circumstances, maybe circumstances that have changed. So by the time the court granted you the order, things have now changed when the tribunal is constituted and you have new evidence and new facts. Then you can go to the tribunal and present those new facts, and then they could grant. So that is one of the cases that demonstrated a situation where you can find a clash between the two who should support each other, and parties might take advantage of that concurrency of jurisdiction to take advantage and forum shop. And I think one of the observations of Justice Mubiri in that particular case was that there are scholars who are of the view that once the tribunal has been constituted, then the court should not come in to even provide those interim protective measures, because the tribunal already has the mandate by virtue of the law and the arbitration agreement to actually provide those remedies. So the court should not come in, no one should go to the courts, and therefore should be left at that. And then it also recognizes the fact that there's another school of thought that thinks the jurisdiction should remain concurrent for situations where you have to enforce against a third party, or where an interim protective measure of an arbitrator may not be respected by the party, and then you can't enforce it. But it was very clear, and there's also reference to the court, to the laws of England, where there's provision that where the matters are before the tribunal should be restricted to the tribunal, and before going to court to seek an interim protective measure, you must get the consent of the opposite party, but also the consent of the tribunal. And I think that's something we need to think about as we review our laws in Uganda, our Arbitration Act, to find a way of avoiding that clash and requiring that either there is that consent of both the tribunal and the party, such that by the time the matter goes to the court, the judge knows that the tribunal has agreed that this matter be forwarded to them. But the other thing, probably because of the lack of the force of law in terms of an interim protective measure granted by a tribunal, if not complied with, there's also need to amend the law to then have them as awards that can be, not awards, sorry, but as measures or orders that can be recognized and enforced by court, such that if there's an injunction that has come from an arbitrator, a person just registers that injunction before the courts, and then they can be enforced the normal way you enforce any other order of court. So in terms of the additional support, for now, I think I can speak to that, and I can give you additional areas where the courts can come in to support in the subsequent conversation. Thank you.
Thank you very much, Olivia. Maybe a follow-up question will be that most arbitration clauses are worded, all disputes arising from this agreement, etc., will be referred to arbitration. Whether it's a clause born out of a sheer laziness or a boilerplate, or it's tactical, is a question for another day. But the question for you today is, in your experience, are all disputes arbitrable?
No, not all disputes are arbitrable. And I think Genevieve had kind of touched on that. You must look, first of all, at the law, the governing law. For example, if you have chosen a particular seat, if it's an international arbitration, the law of the seat usually also will determine arbitrability of the disputes. Or if someone has chosen the law of the arbitration agreement, and they've chosen a particular jurisdiction to govern the arbitration agreement, because that will be the law that will govern what can be arbitrable and what may not be. So in those circumstances, you must look at the law. For example, in Uganda, there are disputes which are not arbitrable, like, for example, criminal matters. And I think that's across most jurisdictions. I'm not aware of a jurisdiction where criminal matters are arbitrable. Criminal matters are not arbitrable. Tax matters are not arbitrable, except where we have international agreements. And indeed, the Income Tax Act and the VAT Act, they recognize the fact that international agreements will supersede. If there's a certain agreement, they will supersede our local domestic laws regarding that issue, if they're referring to a particular. So, but generally, if there are domestic tax matters and there's no international agreement in there that picks another jurisdiction, they are not arbitrable. Employment disputes, employer-employee disputes are not arbitrable. Family disputes, divorce, guardianship, parentage, all those disputes, family-related, are not arbitrable under Ugandan law. So once, assuming you have, let me give an example, probably a couple, and this one I'm just going to give an open example. We hear of prenups or agreements between a couple, for example, and then they get into an agreement to say, in case we have an issue about our children's custody, we'll refer this matter to arbitration, and they sign. Even if they presented that matter to arbitration, it would not, it would be set aside, because the award would be set aside, because the laws of Uganda have given jurisdiction to the courts to determine family-related disputes. So not every dispute is arbitrable, Ambrose. I hope the examples clarify that.
Thank you very much for that. The examples you've given clarify that. We were not joined by Madeline and Victor because of certain engagements which have arisen. As such, we will go to the plenary. For members who are following us online, you can write down your questions in the chat box as we continue, because the session will be shorter than it was anticipated earlier. Now, to start us off in the plenary, if I heard you well, Genevieve, you said that in Uganda, enforcement must be done within 90 days. I know, for example, in Kenya, we do not have a timeline for enforcing, but we have timelines for setting aside. Is it the law, basically, in Uganda that if you don't enforce within 90 days, the door is shut for you to enforce?
Thank you, Ambrose. I hope I can be heard.
Yes,
so just a bit of clarification. Okay. Just a bit of clarification. The 90 days is popular under the arbitration rule, and they refer to the time period for objection if somebody files a notice to enforce. Okay. So then in Uganda, actually under the ACA domestically, and also the 90-day rule applies mostly to foreign awards. If you want to object to it, then we're talking about the 90 days. However, under the Arbitration and Conciliation Act in Uganda, actually, the time for setting aside is the limitation period within which one must file an application set aside is within 1 month of receipt of the award. That is 30 days construed. So it's very important for someone to be mindful of the timelines. And yes, if you're out of time in Uganda, the law says that you're out of time, you're time barred, and then the application to set aside will be dismissed. It will be deemed that the award stands. So generally, though, there's also a limitation period of 6 years within which a party may the party may apply for enforcement generally and recognition. So there's the responsibility. I want us to appreciate the nuances in here. There's the timeline for applying for recognition and enforcement, okay, by the successful party. All right, that is within 6 years. So you've won and you sit on your decision for 6 years, and then you come in the 7th year, you may not be able to benefit from the fruits of that decision because you'll be time barred. So that's the first limitation. And then let's say this person applies within the 6-year time limit, the limitation period, and gives a notice to the other side of intention to enforce. Now the other side has 90 days within which to object to that to the enforcement. Objection and setting aside they have similar grounds, but they're actually different. So for example, you will object that the award is not agreeable with Ugandan law one way or the other. Just because it's not agreeable with Ugandan law doesn't mean that it cannot be recognized somewhere else, for instance, especially when we're talking about awards enforcement or recognition under the New York Convention. So setting aside has similar grounds, very similar grounds, one way or the other. You weren't given fair hearing, there were procedural issues, composition of the tribunal, and so on, similar grounds. However, that is, you want the court to grant an order that this award should be completely set aside. So then you have to file for setting aside within 1 month of the receipt of the award. So this person may file for recognition and enforcement of the award within the time period of 6 years. And then the other party has an obligation to file within 30 days of the award, of the receipt of the award. Where they sit on that right, they may not be given a hearing at court because they'll be time barred.
Thank you once more. Maybe you can clarify to us, is there a definition for the phrase receipt of the award? Does it mean, for example, when the arbitrator informs you that the award is ready for collection upon payment of his fees, does it mean the day you make the payment and actually collect the award? Or exactly what does it mean by the phrase receipt of the award?
Okay, thank you, Ambrose. The date of receipt of the award is the date when it was read out by the tribunal to the parties. So usually after an arbitration proceeding, there is a date that is given by the tribunal for the award. In court language, that would be the date for judgment, okay? The equivalent would be the date for judgment. So, and on the award, it's written, usually, this award has been delivered on this dash day of dash, the year. So that date is very informative of the date when the parties received the award.
Thank you for that. I think in this part of the world, here in Kenya, things are a little bit different because our capitalistic nature catches up with us many times because the arbitrators send a notification that the award is ready and that parties can pick it upon payment of the requisite fees. So that issue has been litigated over and over again. And in one of the decisions, the court has said that the date of the receipt of the award in Kenya is when you receive the notice that the award is ready, and you are required to make the payment or to do whatever is required to be done for you to receive the award. So that makes the little difference between the awards this side and maybe the awards in Uganda, because ours are not necessarily read out in maybe open tribunals or read out to parties. But thank you very much for that. Now, I would like to pose this question to both of you generally. You mentioned that recognition is not the same as enforcement. Now, what will be the process of enforcement post-recognition? And also, as a tactical way, would you advise counsel to do the application for recognition contemporaneously with the application for enforcement?
Ambrose, let me just share my views. I think first of all, the enforcement process is the ordinary enforcement that you would enforce a decree, because once the award has been recognized, then the recognition means that it's being viewed as a decree of court, so as a normal judgment of court. So the enforcement stages, the process would be the same as you'd apply. For example, here I would apply the civil procedure rules, the order on execution. So look at, if I want to attach an asset, then you apply the rules for attachment of that asset, and then apply it to court for attachment of that asset. If it's about garnishing an account, then follow that procedure to garnish the account and recover the proceeds of the award. So that's really the process would be the same enforcement process that would apply when you're enforcing the court order, because at that point in time, it's viewed as a decree. Now, it's advisable to first pursue recognition, because usually once you file the application for recognition, sometimes you're required to actually serve the opposite party, just in the event that there are issues in terms of the authenticity of the award, or that there are issues in the jurisdiction where the award has been issued, or even inter-parties. So it's advisable that you have the award recognized, such that once it's recognized and has gotten the status of a decree, then you pursue the enforcement. You could file them together, but just know that the first step would have to be recognition. So before it's recognized, the enforcement can't start. And like I said, the enforcement is that you have to have an application for execution, for example. So you definitely have two separate applications, so to speak, and then one is considered first before the other. Then once the recognition is done, then the enforcement process follows.
Thank you very much for that. Again, the next question or discussion point is open to both of you. Genevieve, you mentioned that a court will not enforce an award which reserves certain matters before the arbitrator or are still pending before the arbitrator. Is an award save as to cost a final award for the purposes of enforcement, or for the purposes of recognition? Sorry for interusing the two words.
Ambrose, I beg your pardon. Could you kindly clarify the question?
Certain awards will be written final award savers to costs, to mean that the arbitrator has not determined the cost to be paid by the losing party within the arbitration, or by whichever party that the arbitrator thinks should pay the costs. Is that award final for the sake of recognition?
Thank you, Ambrose. Okay, I get you. So the question is that where the award is given with costs to be paid by the opposite party, is it final? Okay, as I earlier explained, the criteria for determining the finality of an award is largely hinged on whether it resolves all the disputes or some of the disputes in question in the arbitration fully. Okay, it could resolve all the disputes fully or resolve one or two of the disputes fully. That is when it's considered a final award that can be enforced. Where it's said that the successful party, of course, they answer their issues in the affirmative, and then they're awarded costs to be paid by the other side. Yes, it does not stop it from being a final award. And now that's where the issue of enforcement comes in. The part where you compel the other party to pay the costs of arbitration forms part of execution, part of the money that the successful party should be paid. That is both the principal sums as may have been decided in the arbitral award and costs of the arbitration. All of that forms part of execution. So the answer is yes, it's a final award.
On the same breath.
Ambrose, maybe just to supplement on what you said. Actually, the enforcement, the recognition and enforcement in our jurisdiction, and I'm trusting even others, is not just for the final awards, but also even a partial award. So it might be a partial award, and as Genevieve earlier had said, that it may not resolve the entire dispute, but it actually handles some of the issues within the arbitration, some of the main issues. So if I use the word main issues, I hope it can be understood, that it resolves part of the issues or the problems in the arbitration. So it may be a partial award, that it has not concluded everything, but so that is enforceable. So same as an award severs to costs, that too is enforceable, because the only part remaining is really the issue of costs, but the liability or the questions, the issues in the dispute have all actually been answered. So such an award can be recognized and enforced. I think it would be a matter of strategy for a party to determine whether to enforce this and then come back to enforce the one on costs, or await both and then enforce them at the same time.
Thank you for that. One elephant in the room is usually the costs of arbitration. And Julius Semuyaba would like to know, from your experience, is third-party funding in arbitration available in East Africa, and which firms provide it?
Third-party funding, I'm not aware if it's available, and probably Ambrose, you'll share if you know if it's available in East Africa. I'm not aware that there's been any third-party funding offered here in our markets in East Africa. But also in terms of embracing third-party funding, I think there's been, how can I call it, a fear because of the rules of champerty and maintenance, the common law rules that barred third parties from participating and maintaining cases, which rules are still applicable within our jurisdiction. So I think sometimes third-party funders are still trying to navigate, because our law has not come out to expressly authorize it, and because we still have the common law rules governing us generally, especially for us, even in Kenya, I want to believe some of the common law principles, unless it's legislated. So there's that. So I've not had, to be honest, unless the arbitration was happening in a different jurisdiction, and probably East African parties are involved, and maybe it's in that jurisdiction it's allowed, but I've not had in East Africa itself where you've had an arbitration happening and then third-party funding has progressed the arbitration. But you could share if in your experience you've had. Although in my recommendation is that's one of the areas we need to think about in terms of even specifically legislating to authorize it, because I think it might be one of the fears why it's not talked about too much, or even the third-party funders are not coming out to say that, we are giving these funds available. It's because maybe the laws have not necessarily come out to actually authorize it. Thank you.
Thank you. The same principles apply here in Kenya, mainly for advocates. I'm not sure whether they apply for common people and for other entities, but for advocates, we are not required to fund suits. What I know happens so that we evade finding ourselves being liable for champerty is most advocates will charge on a contingency basis. That is, they will take the matter almost pro bono, and based on the outcome, even though it is also illegal to do that, they can charge a percentage, which in most cases will be a windfall. So that is what happens in Kenya in terms of funding arbitration or even litigation.
Ambrose, actually in Uganda, even contingency billing is not legal. It's illegal. We have Supreme Court decisions. So I don't know how you're navigating it in your market. I don't know if it's okay or it's also something lawyers are doing on their own. But if a client were to challenge it, then you would find yourselves in trouble, because in Uganda, we have Supreme Court decisions which have said contingency billing is wrong. And I guess it's similar to the Champati principle, that when you get an interest in the case more beyond your legal obligation as counsel, because now you have to earn that amount of money that you've agreed to in the event that you win. So you do anything, including unethical behavior, to ensure that you win. So those waters are also murky for us, both for lawyers, but even for funding. Because you see, the whole principle behind third-party funding is that the third-party funder should be able to recoup the costs. So in the jurisdictions where it's allowed, it means that the third-party funder can actually claim the money. So where you're getting instead of the costs going to, let's say, the claimant, the third-party funder has the legal right to actually claim the costs of the arbitration. But now where the law seems to find some form of illegality in that, that's why I think the waters are murky. I see Madeline has joined us. I hope she can share with us a Tanzanian experience around that when you pose the question to her. Thank you.
Ambrose, if I can supplement on third-party funding, yes, it's definitely an emerging trend in arbitration. It hasn't been so common as far back as over 20 years ago. But what I've seen or what I've come across is that certain countries are adopting it and legislating it with guidelines. So they come up with ethical guidelines where the third party may have to disclose, you don't hide in the background and fund the arbitration and make a profit out of it. They might have to disclose, there might have to be a whole agreement. I know this is happening in Hong Kong, and there may be other jurisdictions, although I still don't know of any such guidelines or legislation or policies in the East African region. It's definitely an emerging trend, and I think we can adopt it with a positive mindset, just like other emerging trends like AI, with the necessary guidelines.
Thank you. Maybe we can welcome Madeline with the same questions that we hear. What are the perspectives from Tanzania?
Thank you so much, and apologies to you all for my late coming to this meeting. I was in a very crucial meeting that speaks to the same comments that we are sharing here with regards to innovative provisions within our legislative framework to enable this particular field of practice. And so if I caught correctly, the question that was being addressed was with regards to third-party funding and access thereof. Is that correct?
That is correct.
Thank you. Indeed, in our new legislation that came into force in January of 2021, this was a matter that was tabled before our parliamentary committee that was charged with drafting that legislation. And so with that comment on their table, what we received was that it was yet to be something that was of usage in the country at that time on that review that was in 2019 or late 2020. And our argument was really that this is a force to recognize at that point, prior to it knocking in our doors. We saw the importance of it. We saw the need for it for purposes of allowing access to justice, to disputants, not only in international arbitration, but also domestic arbitration. And so the proposal was to look in the way of the English, the Singaporeans, in lifting that law of charpanty, which is also in our country. We have this same common law principle of charpanty that sort of gives a blocked wall or a wall that does not allow for this third-party funding to be effected as we've seen in other jurisdictions. And so, yes, it's an issue in discussion. It's an issue that we have put forward for purposes of including it when we're looking into and analyzing and evaluating the effectiveness of the law that has been in practice now for less than 4 years. And so I'm with my colleagues when I say that it's something to look out for. It's an aspect that is a future. It's not futuristic anymore because we've seen it even in the Nachingwea case, which was against the Republic of Tanzania, the United Republic of Tanzania, whereby the claimants in that case, an ITSID matter, were fully funded by a third-party funder, and all those costs that were awarded, except for the additional funding that they had sought from that third-party funder. And so it is something that is creeping in and would need to be regulated in a similar like manner, such as in other common law jurisdictions. I hope I've captured your question well.
You have, and thank you. Thank you also for joining us. Earlier on, the panelists shared their experiences from the region on the critical role the courts play in arbitral disputes. Because we still have time, we would like to give you that opportunity. We know you had definitely prepared something for us, and allow you to address us on the way the two different systems of adjudication can symbiotically coexist and cooperate in the same space. Take it away, Madeleine.
Thank you. Thank you so much, Ambrose. And yes, I did prepare. And I was caught off guard with the meeting that I just had. And so apologies once again, thanking the ELS for its work in advancing ADR, the ADR landscape in the region. A lot of efforts have been done, including a constitution of an ADR committee within the ELS system. And so I really do appreciate having this opportunity to serve on this panel. It was me running from my other meeting just to make it on time, even for the Q&A. And so please accept my apologies once again. I welcome this opportunity, of course, also to address the issues that are on the table for me to address, which is that aspect of discussion on how this the different ways of these two adjudicative systems, which is the court and the arbitration system, can symbiotically coexist and cooperatively interact in the same space. So as probably my previous colleagues have already stated, the courts and arbitration play their separate roles, but connected roles and related roles in international dispute resolution. And although we've come to understand what arbitration is, I won't go into that. I will go to the crux of the matter, which is just looking into how this can be done. Yes, the relationship of the courts is the relationship between the courts we've already identified, and the perspectives, or sometimes it is seen as one which is competition, even hostility at some points. But characterization-wise, we need to understand much more by looking at the legislative frameworks, and which I will try to touch on very briefly. Now, the differences between the judge, and the arbitrator's award, the judge's decision and the arbitrator's award, those are very much well understood. When you look at the judicial decision of a particular case, you understand that there are concrete expressions of law of that land, that is Tanzania. Hierarchically, judicial systems also observe doctrines of stare decisis, where there is adherence to precedent, and judicial decisions affect not only the immediate parties to the dispute, but all other persons with like cases that are between them. So the decisions there, we've understood the differences. In arbitration, there's less call to be concerned about an unwilling party, whereby in the decisions making of the courts, it's not merely a matter of dispute resolution between private parties. Here in arbitration, we understand that both parties have agreed to submit to arbitration from which that power is then derived by the arbitrator, that submission clause in the agreement. So there is a legitimate place for some intervention by the judicial organs of the state, because there are some aspects, and this is where I borrow leaf from the words of Lord Mustill, or Mustil, however you'd want to pronounce it, but he said it very well, if I recall correctly. He stated something like, it is only a court with cohesive powers that could rescue an arbitration which is in danger of foundering. And so, yes, the parties have agreed to submit their arbitration, and the power of the arbitrators derived from that agreement to submit to arbitration. But there comes a time where there is that need for assistance or intervention by the courts to assist the parties to move forward whenever there is a disagreement of some sort embedding that process. And, the overriding principle of party autonomy that is enshrined in our Arbitration Act, if you look at section, I think if I recall, section 4 of our 2020 Revised Edition Act, the principle of party autonomy is embedded in that particular section. The parties should be free to agree how their disputes are resolved and subject to the safeguards as are necessary in the public interest. Now, yes, so we have built certain walls to keep certain things out, and some to keep certain things in. So that's how these two systems work. And the arbitral system serves both of these functions as well. So if we go back to the New York Convention on the enforcement of foreign arbitral awards, and if we look also at the Unicitral Model Law, the supervisory role of the courts is embedded. It's put in there in these two frameworks that national courts, that the parties are able to turn to seek for supervision from these courts. And they can do this for purposes of a stay of proceedings in favor of arbitration. They can do this for purposes of appointing or terminating the appointment of arbitrators, and the whole works. And we've seen this in play. Now, how then, which is the question at hand, how do these two get to work together? How do these two adjudicative functions get to coexist and cooperatively interact in the same space? I won't share a lot of case law which I've prepared, and I'll share my slides, but I'll go to the end of my presentation so that we can allow for much more debate on this. It's that the first point that I have in mind, because I'm here also in my capacity as the president of the Tanzania Institute of Arbitrators, is the coordination with the arbitral institutions such as Tanzania Institute of Arbitrators, Tanzania International Arbitration Center, the National Construction Council, which has also a unit with regards to administering construction-related disputes. The judiciary would actively involve themselves to consider issues that they could harmonize within this particular wheel or basket. And then, of course, with that, we can create valuable forums for more productive exchange of views and how the courts can offer more appropriate support to the arbitration community in Tanzania. We've seen this in Tanzania, and it's working very well, because with the current Chief Justice, we have now a newly formed ADR committee. And these are not only efforts that the Chief Justice alone came up with. It is actually a sort of a network of chief justices from different regions, different countries on the African continent that have seen the need for this particular kind of organ to drive this ADR or arbitration practice in a particular community. And so these are the issues that assist for forging that coexistence and cooperation and forging an interaction between these players in the arbitration and in the court system to create a space that would work together seamlessly. Another aspect maybe that I had noted down on how they can coexist is having these in the current situation where we have this new Arbitration Act that came into force in 2021, we currently don't have any robust practice rules that are court-related rules of procedure for arbitration-related matters that are referred to the court for its assistance, its intervention. As minimalist as it is, according to our Act, there has to be some sort of a broader guidance on the court's arbitration jurisdiction and how the court approaches referrals to arbitration, the enforcement of the awards, the stay applications, the timelines. So the current situation in Tanzania is the issue of timelines, because we don't have these procedural guidances or guidance notes. They are not yet in play to support the new act. We are seeing a lot of matters staying very stagnant for a long time in the court's four walls, which is really defeating the purpose of the arbitration system itself. And so the coexistence through cooperation, as we've noted in the topic at hand, has to be done together with robust provisions to enable the court system to give its support as required under the Act. Other matters which have just come from discussing in terms of reforms and amendments is it's enabling now listening to the arbitration community and responding to its concerns in order to eliminate these uncertainties that I've just touched on. So more practical tools for the arbitration community that would be spearheaded by the judiciary and of course the legislature. But the judiciary has an important role, as it has already done for so long in Tanzania, for being as proactive as it has been, even prior to the Act, upholding arbitration agreements, observing international standards set by the New York Convention on Enforcement of Awards. And so it has been a precedent in our courts that we are proactively and the judiciary is proactively in support of this system that we speak of, which is the arbitration system. The other comment that I had on this coexistence is having now a right time to think of a specialized sort of list of arbitration judges. And this is something that we have floated around in various networkings and conferences. Having this common purpose is going to be able now to really give us our foundation a much more stronger foundation. Is that this dedicated arbitration list would involve arbitration-related would only probably handle arbitration-related disputes. These judges would have their expertise in that particular area of interest, that is of the dispute at hand, and it would give much more greater degree of confidence and certainty on how the judicial intervention that we've already noted it has powers to do so. Those judicial intervention, as minimalist as they are in the Act, will be affected by the fact that this is a specialist list of judges that are going to handle matters that are coming from arbitration-related disputes. So it would also enable to manage this issue of timelines when you make a reference that is related to arbitration in our courts of law. And so with that list, we would also find that within the judiciary, there's more awareness of these judges who are able to then handle such matters of expertise that will be tabled for them to hear. Now, this is something that I'm thinking about as a future issue that would be incorporated in order for these two adjudicative systems to coexist. And in that case, that would have been my submission if I had been able to present the whole paper. Once again, thank you, Ambrose, for allowing me to do the presentation. I would wish to conclude on the fact that the judiciary here in Tanzania is the policy that has been set respects the autonomy of the individuals and those who are organized in such affairs and are in favor of resolving disputes out of the court system using any ADR mechanism recognized under our law. So once again, I thank you, Ambrose, and ELS, and all panelists and participants who are attending for this amazing opportunity to share some of the thoughts on what role the courts can have or the arbitration system can have for both systems to coexist and cooperatively do so. And I welcome any questions and thoughts on the issue that I've just presented regarding these two systems. Thank you so much.
Thank you very much for taking us through your presentation. We hope that you can share the slides later so that we can send them to the participants. In the meantime, especially because you have mentioned that the current act in Tanzania does not have timelines, and you're working towards getting rules which will place specific timelines. Now, given that arbitration aims to resolve disputes as quickly as possible, what is the current, or what have the courts interpreted that to mean in light of the fact that you do not have rules? Have they taken that seriously, or are they dilly-dallying, if we can say that, while delivering decisions on enforcement as well as on setting aside?
That's a very important question. I think the judiciary as a whole has always been forward-thinking and have been somehow aligned to common law practices from jurisdictions that we would usually borrow leaf from. And our judiciary has taken those steps in terms of their judgments, in terms of their rulings with regards to matters before them. But where we come with the problem of observing time, observing, unwanted litigation, it's really up to the practitioners themselves because of this understanding that they have this loophole to take advantage. For example, we have a section that is on serious irregularity matters, where you could raise a challenge to a particular domestic award on a serious irregularity under Section 74, if I recall, 73 of the Act. And that in itself it can take a year and a half for that petition to carry out its life in a court of law if you are in the High Court. The commercial court, we've seen much more swifter decisions being made, but there's still that element where the practitioner is using all means to ensure that it's an elongated process. And that is because of the loop in the law that does not guide us with regards to the timelines for these applications, maybe a network of applications, if you're going to make a network of them, spinning out from the petition to challenge the award, stay of these proceedings going on to the Court of Appeal with POs and so on and so forth. So it's really an aggressive system that would still need the procedural rules that would guide parties and tell them, okay, you've got an arbitration-related matter. This is how you go about it. You cannot use the Civil Procedure Code to find your way in different forums, just to challenge one award or to challenge an arbitrator position and seek for his removal through the process that as we know it. And so the rules would aid us in assisting practitioners to seek these measures or interventionist measures from the court in a much more streamed-like manner as to what we're seeing now. So there's really a big mess.
Thank you for that. 1 year looks like a child's play in our jurisdiction because we have instances, for example, I'm just sharing my screen right now, when the courts have stayed with decisions or before a matter is determined, maybe again because of the ingenuity or disingenuity of the parties for so long. For example, in this arbitration, which I've just shared, I don't know if you can see it, it lasted 17 years. There are many others I could share, including some that lasted for 11 years, 12 years. Yet, in our jurisdiction, we do not have what you call tiers of appeal as far as arbitration is concerned. The High Court is usually the last resort of recourse, unless your matter raises what they call general public importance issues, in which case you can appeal to the Court of Appeal. But in the instant case, calling you to aggravate, the matter went all the way to the Supreme Court of Kenya. So I don't know if that is the case in Tanzania, and also I don't know if it is the case in Uganda, where despite getting your award, sometimes on time, you will spend much more time litigating, thereby negating the need to even have that arbitration clause in the agreement from the word go, or maybe you have better ways in which you deal with these issues.
Well, in Tanzania, I think we've improved. We've very much moved away from this kind of lag. We have had amazing judgments come out on a very swift basis from the High Court Commercial Division and the High Court itself. We do also have levels of appeal of certain decisions to the Court of Appeal. A great example, I think, is the case of RX Energy, which really does set a good timeline to observe when it comes to issues that were attached to this particular arbitration, because it had a lot of issues that were attached to it. It started off with wanting to remove one of the arbitrators based on bias. It went on to the Court of Appeal, which confirmed that it was a right decision by the court, that there was no bias in play. It was only the efforts of the party that was requesting for the removal of that arbitrator to create some sort of a delay tactic of some sort, or bring up issues of bias that are not really bias. From the judgment itself, it says that these were not issues of bias, but just a fear on the part of the respondent, which cannot be proved in any sort of way. So with that was in 2022, I think, that judgment, 2022, 2021. By the time 2023, the award had already been issued by that same tribunal, including that arbitrator that had been attempted to be removed. Now, when it came to enforcement of the award in 2024, so the time framework, you can see it's very quick, very swift. In 2024, there's a Court of Appeal judgment on the same, that the award is final and binding, and that the party that has now challenged, which is I think it was Oilcom Tanzania Limited, that now has challenged on the same issue that has already been adjudicated by the High Court, cannot rely on that as a serious irregularity. And so it held that that particular award was final and a judgment and a decree of the court on the basis, of course, of Section 73 of the Act. And so I could say that the judiciary has been well informed of this need to live up to the requirements or the set principles and objectives of the Arbitration Act. And this has been done through a lot of sensitization, and because of this new law bringing much more understanding of what is required of our judiciary. And so we've not seen this kind of case of 17, 11 years, 10 years, as we might have seen maybe a decade back.
Thank you. Genevieve, maybe you could speak to the same issue. Do Ugandan courts have more than one tier of appeals once you set aside the decision or once you are aggrieved with a decision to enforce? And what would be the yardstick be? What would be the measure be for a party to be able to go to a higher court once you are dissatisfied with the High Court?
Thank you, Ambrose. Now, in addressing this question, we have to be mindful of the general rule that the courts in Uganda principally do not allow for appeal of an arbitral award. Okay, an arbitral award decided on the merits cannot be appealed to a court of law, because the court's duty is not to rectify what the tribunal did, not to change anything that the tribunal did within their discretion as granted to them by the parties in their agreement. Now, when it comes to the decision of the court to set aside or to decline to set aside an award, court often makes a ruling, and that ruling may be subject to appeal as a ruling of that court, limited to the reasons why the court decided not to set aside or the reasons why the court decided to set aside. I hope that a little difference can be appreciated. So it's not about the merits of what was determined in the award. It's about this other decision by the court to refuse or to set aside.
Thank you.
Ambrose, I probably could supplement.
Yes.
If I could, is that okay? Probably, actually, initially the position was such that parties could appeal the decision of the High Court on set aside, whether the High Court was right in terms of the decision. But the jurisprudence coming out of the courts lately is that there is no right of appeal to the Court of Appeal against a decision of the High Court regarding setting aside of an award. So the court has recognized that the Act specifically gives circumstances under which courts should come in, and a right of appeal is not automatic. Parties would raise the general powers of appeal to bring them into appealing against the decision of the High Court regarding set aside, but the recent decisions have indicated that there is no right of appeal against that decision, and the courts recently have also indicated that there are only specific circumstances under the Act which allow for you to appeal. And the court, there's a section 38.3 of our Arbitration and Conciliation Act where parties, if by consent they had agreed to have an appeal to the Court of Appeal on matters of law, then they would seek the leave of the High Court to appeal. So it's only in those circumstances that the court can consider, first of all, an application for leave to appeal if there's the consent of the opposite party to that appeal, the proposed appeal to the Court of Appeal. But without that, the courts have said the Act is clear. If you choose your arbitrator and the High Court either sets aside or doesn't set aside the award, you can't appeal to the next level. So in Uganda, there is the case of Zabo Power Limited and others versus Great Lakes Energy Company, NV. It's a 2022 decision. And in fact, the judge also analyzed the Newto Agrovet Limited case, the Kenyan case, where the case allows certain circumstances where the court can intervene and consider an appeal. Although in a way he said that the court looked at other jurisdictions like Canada and come into that decision, and where those jurisdictions provide for those instances of appeal in their laws. And he found that he didn't think the law of Kenya provided for those avenues, and he felt that the court kind of, used its judicial creativity in terms of coming up with some of the circumstances that did in that particular case. But it says for Uganda, the law doesn't provide that right, except under Section 38, where the party has agreed. and that there were matters of law that were to be taken to the Court of Appeal from the High Court. Thank you.
Thank you. In Kenya, actually, the law does not allow for one to appeal an arbitral award. What it allows is only setting aside or enforcing. But from the High Court to the Court of Appeal, there are times when you can appeal on very limited grounds. That is when the Court of Appeal certifies the matter to be a matter of general public importance. In that case, you will not necessarily be interrogating the facts of a specific case, but you will be giving the matter a public interest connotation, or showing that it's not necessarily an issue specific to the case, but a matter which traverses the general public for you to be allowed to appeal to the Court of Appeal. I agree with you in terms of your opinion that from there, the law does not allow us to appeal further to the Supreme Court. But in this case, the Supreme Court made certain jurisprudential findings and found that it could assume jurisdiction only for the purposes of referring the matter to the Court of Appeal, for the Court of Appeal to certify it as a matter of general public importance, and for it to deal with the matter in finality. So that is the same principle that applies on this side of the border. So at this point, because we are just 2 minutes from our time, I will give each of the panelists a quick minute to make their closing remarks. Thank you very much. It has been very enjoyable. You've kept it very entertaining, and also you've taught us a lot of things. I am now very much interested in what is going on around the region, especially in Tanzania, because I hear they have a law which does not have timelines. Maybe I will need to interrogate that and appreciate what we have over this side of the border again. And also thanks to Gabriel and to the entire ELS team. Maybe you can go first, Olivia. Olivia, we
sorry,
would like to hear you.
Sorry, I didn't know that you had asked me to go. Okay, thank you very much. I want to thank, first of all, my fellow panelists for such an interesting and engaging conversation. I want to thank the participants and the amazing questions that have been put in here and comments in terms of the discourse, and then of course thank East Africa Law Society, and indeed we have to look at each other as the region, because like I said, especially in that the question of the appeal from the High Court to the Court of Appeal on the decision of the High Court regarding setting aside, not appeal against the award, but appeal against the decision of the High Court regarding setting aside. The position now in Uganda is that you don't have the right. I see now Kenya, there are some special circumstances where such an appeal can be considered, especially if it has a public interest or public policy connotation in terms of the decision that the grounds that the High Court based on to make that decision, whether to set aside or not. And I think that's something that might be litigated upon more in Uganda, much as our court actually examined it.
I am not able to hear you, Olivia. I don't know if the rest of the panelists can hear you.
I've lost Olivia.
No, I don't hear her either.
In the interest of time, Genevieve, you can give your closing remarks.
Thank you, Ambrose. And thank you to EALS for this very educative and productive session on arbitration. Oh, Olivia is back. Olivia, would you like to conclude?
Sorry, yeah,
we had lost you.
Thanks. So I think, yeah, that we probably need to work together in terms of the concept of third-party funding and how that can fit within our jurisdictions, different jurisdictions as the East African region as a bloc, and then we can then pursue a regional probably amendment of our laws to support it. And then obviously the correlation between the two systems, I see that all our jurisdictions have grown in terms of, you can see that the courts are working well with arbitration. And recently we had a ULS arbitration conversation where the judges actually were there. We had a justice of the Court of Appeal who was part of the conversation, and the High Court Commercial Division judge. And he was speaking to the fact that the judiciary is really keen. And now we have the Chief Justice has started the ADR, you know, what should I call it, the ADR summit or forum where the judiciary are working together to come up with an ADR policy together with the Ministry of Justice and promote ADR generally and alternative justice systems. So I think we have an avenue as a region to work together to be able to enhance ADR and arbitration and see how we can amend our laws then to promote it further in our jurisdictions. I think I saw that one of the participants had put something in the chat about KEDA. You know, in Uganda there's a process now where some of the institutions are being taken back to their mother ministries. So KEDA, there's a thought that KEDA is going to be taken back to the Ministry of Justice, and the question is, how is that going to affect the growth we have achieved in arbitration? Well, I think that's a question we'll navigate as we amend the law. Probably it can become, KEDA might become a regulator and regulates all arbitral institutions in Uganda under the ministry, or we will have to discuss those with the Attorney General. But I see a bright future for us, and let's work together as a region to grow ADR and arbitration. Thank you.
Thank you. Genevieve?
Thank you, Ambrose. And thank you so much to East Africa Law Society for the opportunity to participate in this panel. It's definitely been very insightful, even for me, learning from the other panelists as well, and the opportunity to share the experiences that I've had in Uganda as well. It'd be great to practice across the border so that we can have a feel of the situation in other neighboring countries, especially Tanzania's case seems very interesting there. I appreciate that most of our arbitration laws are similar, one way or the other, because we have adopted the ancestral model law. But I'm grateful to the participants as well for the questions that they asked that directed us in different perspectives concerning arbitration. We were able to delve deeper into some of these issues, especially things to do with the appeal and managing that thin line between overturning the arbitral decision or interfering, like some people called it. I'd like to call it intervening one way or the other by the courts. It's not all bad. Some people think that because of the court's involvement, there's no point to arbitration, yet it's supposed to be an alternative. But I think we can go with the positives. Like with any system, it's great to have checks and balances. And so the courts being available with an existing system already, it makes sense that they should be able to check some of the procedures involved in the arbitral proceedings. That said, I'd like to thank you, Ambrose, for guiding this discussion, for your insights as well. You definitely pitched in with the experience from Kenya, which was awesome. Thank you so much, everybody, and have a great day.
Thank you very much, Madam.
Thank you, Ambrose, and thank you once again to the ELS for having this particular webinar, and it has indeed been quite a fruitful last 1 hour, which I've been able to attend. I have already learned much from both or from all the jurisdictions that have been represented here today. On the part of the Tanzanian experience, it's really correct when Genevieve says that we are similar in many aspects, that we adopted the Arbitration Act of 1996 of the United Kingdom. And so there are certain elements in our legislative framework that are pretty much a mirroring effect to the UK regime on arbitration. And so we find ourselves in an uncertain time for it to operationalize to where the levels the English courts are. And so my comment with regards to the timelines was really on the procedural aspects of the court, but not the arbitration as it is contained in the Arbitration Act, a revised edition of 2020. And yes, indeed, we are similar in terms of the right to appeal. This is very limited, and it needs the leave of the court for one to be able to appeal a decision of the High Court with regards to a matter that stems out of an arbitration, be it a set aside or removal of an arbitrator issue. And so, yes, we're very much similar, and we looking into each other's windows are the learning experiences from each state is very, very enriching. So I thank you once again, and I thank you for the opportunity to make the short presentation that I did. And as promised, I will circulate my slides for purposes of enabling every attendee to have a full breadth of the presentation that I had. Thank you so much once again.
Thank you very much. Thank you to our participants. At this juncture, we have come to the end of the webinar. Thank you for all of you making it very worthwhile. We will share the slides. Also, this session is recorded, and it's also on YouTube in case you may want to refer to it later. And see you all on the 29th East Africa Law Society Annual Conference from 27th to 30th in Kampala. Have a good day, and God bless you.
Thank you. Good day. God bless.
Bye-bye.
Thank you. Bye-bye.